So let's get started. Welcome everyone to this constitutional conversation tonight, which is being co-sponsored by the Stanford chapter of the Federalist Society. And it is, I'm Michael McConnell, and it's nice to see so many familiar faces and so many new faces here tonight. Our guest speaker tonight is Noah Feldman from Harvard Law School, who's going to be speaking about James Madison. Not just the James Madison, the constitutional framer, whom we speak of so frequently, but also James Madison, the politician, James Madison, the president, the full three-part James Madison. Now, I'm not going to give a long introduction. I will say this, I think the last at least 2, maybe 3 times I've shared a platform with Noah. He and I have been debating, and let me tell you, it's nicer to be introducing him than debating him. He has one of the most interesting backgrounds in, among all people teaching law in major law schools, I think. So he grew up as an Orthodox Jew in, was it New York, at the Maimonides School, Boston, and then becomes a scholar in Islamic studies and Islamic law, getting a degree from Oxford on that subject, becoming a consultant to the provisional government in Iraq after the American invasion there, and particularly a consultant on the formation of the Iraqi Constitution. He then came back to the U.S., entered academia, is now the Felix Frankfurter professor at Harvard Law School. He's written, 7 or 8 major books. The main themes have been law and religion, a lot of focus on Islam, but he's also writes in the field of history. This is his second, what I would consider to be sort of a straight history book. One was about the justices in the New Deal court, and his newest book, The 3 Lives of James Madison, is what he's going to be talking about tonight. So welcome, Noah.
Michael, thank you very, very much for that very generous introduction. I'm honored to be here tonight. I have many friends and colleagues here at the law school and at the university whom I admire very much, and Michael is first among them. Someone who, for anyone who came into the field of legal studies studying law and religion, Michael was the figure to look up to. And as you all know, in academia, the way you show your admiration for somebody is by disagreeing with them ritually. And so when Michael talks about the challenges of debate, I think it's enough to say that, at least on my side, it comes from a place of deep admiration. I should also mention Jack Rakov, who I don't think anyone should say the word James Madison without recognizing Professor Rakov of Stanford, but Jack wrote to me that he is in Italy and his life is tough, and he was really sorry that he couldn't make it tonight. So, the life of the academy sometimes has its upsides. I'm also really pleased to have been invited to speak by the Federalist Society, the only institution that has an actual cameo, literal cameo, of James Madison on its logo. I think that's pretty great. And it also frames the juxtaposition with the word Federalist and Madison, frames what I think is a nice way to introduce my topic this evening. And you might call my short title, what does it mean to say that James Madison was a Federalist? Especially because James Madison himself was, of course, famously one of the co-authors of the Federalist Papers. So in that sense, there's no question that he was a Federalist. And he was a very strong advocate of the ratification of the Constitution, which he had done more than any other one person to design and draft. So in that sense, he was a Federalist because the people who sought ratification of the Constitution came to be called Federalists and referred to those on the other side as anti-Federalists. But then, and I'll get to this, once the Washington administration was in place and the first 2 American political parties began to form, it was Alexander Hamilton, who had been his co-author on the Federalist Papers, who rather brilliantly co-opted the name Federalist for his political party. And since Madison had to form a political party on the other side, which he called Republican, its critics called it Democratic Republican, but they just preferred to call it Republican, Madison ended up being very much the opposite of a federalist in the later sense of that word. All of this should show you that terminology moves, and it moves fast. So my goal tonight is to say a few words about the moves in Madison's own set of beliefs about the Constitution and about its relationship between, about the way the Constitution framed the relationship between, in particular, the federal government and the states, which is a central issue for the Federalist Society and for the word federalism, which often in our contemporary form of legal English refers to precisely this relationship between the central government and the states. And in the process, I'm going to talk about how Madison deeply flipped. And this is mildly controversial. There is a trend of thought associated, especially with the very great historian Gordon Wood of Brown University, which argues that Madison never changed his opinions at any point in his life. And I'm going to respectfully disagree with that perspective. Okay, so what I want you to do now is transport yourselves, close your eyes, be mindful, I guess not if you're eating, close your eyes, meditate for a moment, and picture yourselves in 1784, 1785. So the relevant facts that you need to keep in mind are the Revolutionary War is over, so the necessity of the different 13 states to stick together in order to win the war is gone. And the United States, all of the states, are in a desperate cash crunch. There is no hard currency to be found anywhere in the North American colonies, with the exception of Canada. And there are multiple reasons for this, one having to do with the war, but the most fundamental one is that 18th century empires functioned a little bit like free trade zones. So you have to think of the British Empire a bit like the European Union on a global scale, or like NAFTA. To be part of the British Empire was to have free trade with all other ports that were also part of the British Empire. And it also meant the exclusion of other empires from those ports. And the British Empire was already going global. It had North American holdings. It had West Indian holdings, like Jamaica. And through the British East India Company, it was just developing also control of Bengal. When the 13 colonies struck out and declared their independence, they did a version of Brexit. You could call it proto-Brexit. They left the British Empire, and that means they simultaneously lost access, not preferential access, but in many cases total access to the ports where they had previously traded. And this was an important structural cause precipitating this cash crunch, and it was the most serious economic problem facing the United States because it had no obvious solution. Under these circumstances, James Madison, among others, fixated on the question of how the United States could possibly deal with the problem of getting enough leverage to force Britain to allow American ships access to its ports. Arms were out of the question. At the very end of my comments, I might touch very briefly on the War of 1812, which, believe it or not, is a fascinating topic, but I want to hold you, so I'm going to make you wait on that, where the United States, under James Madison's presidency, actually did threaten and then try to use force to achieve this end. But as of this moment in 1784, another war with Britain was completely out of the question. The United States was very lucky to have survived the war. It had no navy to speak of. It had not much of a standing army. What they had been disbanded after the Revolution. Meanwhile, its soldiers had not been paid. They remained unpaid. And so military leverage was not an option. That meant that the only option was to use trade sanctions. And the problem with trade sanctions, if you have 13 colonies, is you can't get a single coordinated trade policy. If you have to blame someone for this, you could blame Rhode Island. And the framers did. Every time the Continental Congress, or then the Congress under the Articles of Confederation, would declare that you couldn't trade with Britain in this or this or this way, everyone would stop for a little while, and then Rhode Island would immediately start doing it and filling in the trade. And by doing that and free riding, they then would break the consensus, and then everybody would begin to trade. So Madison thought that what the central government needed was the specific coercive authority to force the states to comply with trade policy. And in his notes, he was extremely radically centralizing when he fantasized about this, and it was a fantasy. For example, in his earlier thoughts, before he drafted the Virginia plan that became the plan for the Constitution, he actually wrote that the central government should have just a large enough navy so that if a state broke trade policy, the central government could blockade that state. And if necessary, he said, a few gunships will solve that problem. Now, it's striking because this is, the same person who very shortly thereafter will actually think that the United States should have almost no navy at all. But I'm just mentioning this to show you that what fundamentally motivated Madison initially to need a central constitutional government was trade policy. A second problem began to obsess him in the year between 1786, when the Annapolis Convention. How many people ever here who are not specialists have ever heard of the Annapolis Convention? Right, so there's a reason for that. It's because it failed. The Annapolis Convention wanted to be the Philadelphia Convention, but it just wasn't up to the job. Only a few people showed up, and it was an obvious disaster, and actually Hamilton saved the day by writing a document that said, we're so excited to be here, this is so great, and we think we're going to call for another convention, because this is being so successful, another convention in Philadelphia next May. So that's literally the role that the Annapolis Convention played in U.S. history. It was a failed convention. So in the year after that failed convention, Madison became increasingly obsessed with a second problem. And this was not a problem at the national level. This was a problem at the individual state levels. His obsessive concern now was the issuance of paper currency by the states, which had the effect of massively inflating all of the currency in the country, because the paper wasn't worth very much, with the effect of enriching, if that's the word, debtors at the expense of creditors. Right? If someone owes a debt and it's denominated in the currency of the state, and that currency is rapidly inflating, that's a disaster for people who are holding the debt, and it's great for the debtors. And this concern drove Madison in that summer to develop the belief that the new central government that he was beginning to imagine would also have to have the capacity to coerce the states not to issue these kinds of inflationary currencies. So to the concern of coercing the states to participate in trade policy, he added the concern to coerce the states so that they wouldn't cause inflation, which would dispossess property holders and specifically creditors while advantaging debtors. The plan he produced, the one that makes him a genius, the fundamental Virginia plan that became, with some important tweaks, the ultimate Constitution of the United States, was designed by Madison to address both of these issues. And the magic sauce, in his view, was that the central government, and notice I haven't used the word federal until now. That's because Madison didn't use the word federal. In the first few weeks of the convention, people referred to the central government as the national government. The national government, as they described it, and was designed in Madison's plan, would have the capacity to make laws that directly bound individuals living in the states, while simultaneously giving Congress a veto power over any state legislative act it didn't like. So picture how nationalist that is, how focused on central power. That is not a states' rights picture. And although Madison was not one of those who hinted darkly at the Philadelphia Convention that they could do without the states altogether, he was not unsympathetic to that view. So Madison was not a states' rights thinker going into the convention. That did not mean he didn't care about his native Virginia. If the negotiations broke down, as it seemed they probably would, he was strategizing for what Virginia should do in the aftermath, because that would be the only thing standing. And that was his home state. And indeed, one of the things that fascinated me in studying the 18th century is that when an 18th century American refers to my country, he's always talking about his state. His country is his state. So I'm not saying that Madison wasn't deeply committed to the interests of Virginia, but he believed that the interests of Virginia ultimately would be served by this very strong national government. At the Philadelphia Convention, every single time he brought up the veto power, he was voted down. No one wanted to hear it. And there's a reason for that. It's that in the run-up to the convention, nobody else of those who really wanted a constitution was very worried about the fundamental problem that Madison was worried about, namely the tyranny of the majority in the state legislatures, where the majority were debtors. So you're all familiar with that expression, the tyranny of the majority, which has come subsequently in American history to be used to justify judicial intervention and judicial review to protect minorities. We'll leave aside the question of judicial review for the Q&A if people want. That was not Madison's primary institutional design, but he was very worried about the tyranny of the majority. But to be clear, the majority he was worried about were people who owed money, because there were always more of those than people who had lent money. And so that majority would be likely to pass legislation that would essentially dispossess or rip off the minority of creditors. But because nobody else was very focused on this problem, Madison couldn't get this idea of a national veto through, and he actually left Philadelphia deeply frustrated about this, because among other things, he thought it left a hole in the middle of the Constitution. So what was the hole? Let me just describe it briefly, because it's of contemporary relevance to us today. The hole was that this national government, which had come to, well, I'll say a word about the meaning of the word federal in just 30 seconds. But this national government, as it had developed, could pass laws that bound people in the states. But it wasn't completely clear what would happen if the states refused to comply with those laws. There was no mechanism built in to say who would win. So Justice Anthony Kennedy, in one of his, Justice Kennedy likes high-flown phrases. And sometimes they really work, and sometimes they work less well. You can judge whether this one works or not, but in one of his opinions, Justice Kennedy says that the founders, quote, split the atom of sovereignty. I think he means in the positive sense of splitting the atom, that it released all kinds of wonderful energies. So take it that that's what he means. So what Justice Kennedy is referring to there is the idea that sovereignty used to be thought to mean, literally, whoever has the final say is sovereign. That's the definition of the sovereign. In this Constitution, as it emerged from Philadelphia, there were states that had sovereignty over some things. There was the federal government that had sovereignty over things. There's the splitting of the sovereignty, splitting of the atom. But Madison thought there was no fail-safe check on this splitting, because in the end, in the case of conflict, no one would truly be in charge. In my view, that was a deeply prescient concern. But the only way to get the Constitution ratified ultimately was just to leave that hole there. So Madison left the convention with this Constitution in place, and as part of the move in the second half of the convention, the following thing happened to the word federal. So going in to the convention, Madison's form of central government was called the national government, and his form of government was described as a national form. Those who favored the maintenance of significant sovereign power among the states called their system federal, in the literal sense of a federation, as in the Articles of Confederation. See, the word federal is in there. So the original debate was national versus federal, right? The compromise that they came out with was a hybrid. It wasn't truly national, and it wasn't truly federal. And they had a lot of trouble in the convention inwardly figuring out what to call it. And luckily, Alexander Hamilton, one of the greatest public relations specialists, except when it came to himself, in the history of the United States, brilliantly hit upon the idea of insisting on calling the government a federal government and referring to the propagandistic essays, very brilliant propaganda, but propaganda nevertheless, that he and Madison produced together, John Jay wrote a few also, as the Federalist Papers, thereby co-opting the term Federalist for a government that its critics were saying was truly national. I mean, pity the poor anti-Federalists. I mean, what an incoherent position they were in. We'd already had a federation. To be anti-federal sounded like you didn't even want a federation. You wanted 13 separate states. I mean, that's clever grasping of the central rhetorical ground. And it was only the first time that Hamilton did that with the word federal. Okay, so that's the end of the first of Madison's lives. It's the drafting of the Constitution. It's this compromise where he's very worried about what happened, but he needs ratification, and ratification ultimately occurs. Washington becomes president, Hamilton becomes Secretary of the Treasury, and Phase 2 begins. What happens in Phase 2, rather remarkably, is that Hamilton, who was not very engaged at the Constitutional Convention, his attendance was sporadic. And he gave only one really notable speech. And in that notable speech, he said that the only form of government that could ever work for a government like the United States was the British Empire. We needed to be a monarchy, a constitutional monarchy to be sure, but a monarchy nevertheless. That we needed to become industrial the way Britain was industrial. That we needed a cabinet government, that is to say government from the center, where the members of the legislature could be co-opted by the executive. And we needed a large navy to go around the world and start conquering people the way the British did. None of these things played well in the room. And Hamilton, realizing he had overstated or missed his mark, left, didn't come back for most of the rest of the summer. But he was waiting for something. And what he was waiting for was an actual government. And now he set out to do for the financial system what Madison had done for the structure of government itself. And just to oversimplify slightly, what Hamilton wanted was a national bank, which would create a bond market, a national debt, which he said would be, quote, immortal and perpetual. He was right about that. And subsidies for manufacturing to pull the United States kicking and screaming into the age of the Industrial Revolution, which was already getting going in Britain and which we were late to the party on. His stated rationale, and this is the amazing thing about studying Hamilton, he always told you what he was thinking, was that he wanted the financial markets, the bond markets he was creating, to have much greater influence in the Republic than any other actor, because they would, A, demand that the government keep lending them money, so there would be liquidity in the bond market, and B, make the government raise taxes to pay them back so they would get paid back. Then the government would have money, then he could do stuff. By stuff, he meant grow, get a navy, start conquering other countries. So that was his picture, and Madison thought that this was disastrous from a policy perspective, and over the course of several years where he and Hamilton fell out and went from being good friends to being vicious enemies, personal and political, that was Hamilton's phrase, Madison also invented the idea that Hamilton's ideas were not just bad policy, were not just wrong, but were actually unconstitutional. So in this phase, Madison initiated the practice, which is still with us in the United States, where your partisan opponents aren't just wrong, but they're trying to subvert the very structure of the Constitution itself. We've certainly seen this in the most recent election on both sides. Right? Both sides think that the other side isn't just wrong, but is interested in subverting the basic structure of the Constitution. Madison invented this in the course of creating a political party, and here he didn't have the benefit of being on Hamilton's side, so when Hamilton declared his party the Federalist Party, Madison had to come up with something else, namely Republican. At this point, federalism became the view that the federal government, as it was now called, had tremendous power to do all the things that Hamilton wanted it to do. Among other things, Hamilton had the view that the general welfare clause of the Constitution that says that Congress has the power to provide for the general welfare meant that Congress didn't have to be limited to the enumerated powers that were listed in Article 1, Section 8 of the Constitution. That may sound heretical today, but it wasn't so clear at the time that the enumerated powers were the whole story. And Madison, in response to Hamilton's bank ideas, had to develop for the first time the idea that these enumerated powers were a limit on what the government could do, and that anything that went beyond that was unconstitutional. So in this period, Madison became a partisan, and he changed drastically. In the course of his partisanship, he even went so far as Jefferson's views, which were pretty out there, arguing that the United States shouldn't even be an industrial republic at all. Previously, Madison had said we should be a mix. We need some industry, we need some agriculture, we need a little bit of everything. He was a moderate guy instinctively, and that was a moderate view. But when you're trying to find a political party, that doesn't really do the trick. You need to state the case a little more strongly. Simultaneously, Madison, so that was the first move on Madison's part. Under the pressure of partisanship, he started to dispute the idea that we should be industrial at all, and he started to make the argument that the Federalists' views, Hamilton's views, were unconstitutional. The second crucial element of Madison's move in the direction, the second life, in the direction of states' rights, came in the Adams administration with the passage of the Sedition Act. So the Sedition Act, sometimes also associated with the Alien Act, which was passed at the same time. Those are called the Alien and Sedition Acts. But the Sedition Act, which was the main focus, made it a crime to criticize the government. the federal government. This is a federal law enforced around the country, giving jail time and big fines to editors of newspapers whom Adams didn't like. And it was consistently enforced. And then the question was, what do you do about this? And Jefferson and Madison each produced a document anonymously. Jefferson's was for the Kentucky legislature, the Kentucky Resolves. Madison's slightly more moderate one was for the Virginia legislature, the Virginia Resolves, in which they stated, in Jefferson's case explicitly, that when the federal government passed an unconstitutional law, the states should, quote, interpose themselves against that law. Now, to Jefferson, interposition meant don't enforce the law, and maybe even more, stand up to the federal government. Madison, who had a slightly more moderate position, just thought the states should stand up and insist the law was unconstitutional. That was his slightly more moderate position. But notice that Madison was at this point deeply enmeshed in the discourse of states' rights, and see how he was almost 180 degrees the opposite of where he was going into the convention. Going to the convention, he needed the central government, the national government, in order to make the states do stuff, including have a nationalized trade policy. He had wanted Congress to be able to veto state legislative acts. Now here he was saying that state legislatures were the last best bastion of protection against the national government. He had genuinely flipped. And he had flipped because he had seen what the Federalist Party had done. He believed that the Sedition Act arrogantly violated the First Amendment, violated the freedom of the press. But the Federalists had a theory about why it didn't. Happy to talk about that in Q&A. And they controlled the courts, so they were getting convictions. So you see, Madison had really shifted at this stage. Now, last act, and I'll do it in about 3 minutes so that we can have a conversation, real conversation. In the third of Madison's lives, the Republicans came to power. So Madison hated political parties. He thought they were bad and wrong. So why did he found one? Because the Federalists did it first, as far as he was concerned. He believed a party was justified for only one purpose. Can anyone guess what that purpose would be? Destroy the other political party, because that party was a threat to the Constitution. So the Republican Party had a purpose, which was to abolish all parties by abolishing the Federalists. And by the lights of Jefferson and Madison, that's what happened in the election of 1800, which they called the Revolution of 1800. They thought the Federalists were done. So today, when we hear Jefferson's famous line from his inaugural address in 1801, "We are all Republicans, we are all Federalists," that sounds to us like some beautiful invocation of bipartisanship. It wasn't. What it meant is, we were all Republicans, we're all Federalists, i.e., you don't have a party anymore. That was its actual meaning and context. That's actually one of the most fun things about doing research like this. You just discover how things that are used, famous phrases from history that are used today to stand for some very clear proposition, actually meant something pretty close to the opposite in their original context. I found a couple of great ones like that. This is one of them. So now the Republicans were in charge, and that turned out to be a tricky place to be, partly because when you control the federal government, you want to do stuff. You suddenly have a slightly different view of federal power than you did when you were out of power. First conflict, Louisiana Purchase. Best deal anyone's ever gotten, based essentially on the fact that Napoleon, who had wanted to rebuild a French empire in the Americas, started with Haiti, and the yellow fever destroyed a 60,000-man French army that was sent to put down Toussaint Louverture's rebellion. And so Napoleon gave up on the whole idea of a North American empire, and that meant that the entire Louisiana territory, which he had forced Spain to give him, was now not worth anything to him. So he turned around and offered it for sale. And without thinking twice about it, the Americans said yes. The problem was there was nothing in the Constitution that provided for the acquisition of a vast territory and its eventual incorporation into the United States. So Jefferson, who was a real states' rights supporter and believed in limited government, told Madison, we need a constitutional amendment for this. And Madison said, well, I see what you're saying, but there's a problem with that. The problem is we don't have time for a constitutional amendment, because if we don't buy this right now, Napoleon's going to change his mind. And Madison was Secretary of State. So Jefferson said, okay, let's just buy it and worry about the constitutional problem afterwards. And so then he said to Madison, okay, here's my proposed constitutional amendment. We go into Congress and we tell them, hey, we broke the Constitution because this was a once-in-a-lifetime deal. please retrospectively ratify it with an amendment, which from a legal standpoint makes perfect sense. I mean, and actually, Jefferson gave the example of literally a trustee who has an opportunity for a great business deal, breaks the terms of the trust to do the deal, and then goes later and says, hey, I'm really sorry, but can you retrospectively ratify it? So Madison, and by now the purchase had been made. So Madison sort of slowly, subtly trying to modify Jefferson, which is one of his great jobs in life, to modify Jefferson's radicalism, pointed out that if you announced that you had broken the Constitution, you were not setting a great precedent for future governments feeling that they were obligated to follow the Constitution. So much better, Madison thought, just to let the whole thing slide and just not talk so much about how the purchase violated the Constitution. And that's what they did. So already pretty different from the strict construction government of enumerated powers. And then came the question of how to enforce Madison's renewed economic efforts to force Britain still to allow US shipping. And here, Madison came up with the idea of an embargo, trade sanctions, which again were necessary because the United States had almost no navy and no army, and the British had the greatest navy known to the world and a non-trivial army, albeit very busily engaged fighting Napoleon. So the embargo was an approach which simply said, we're not going to sell you anything. The only small problem with an embargo is enforcing it. In order to enforce it, the Republican administration under Jefferson, with Madison's urging, essentially enacted legislation that gave federal officers close to total control to seize without warning the shipping of Americans who went to sea claiming they were going to other places on the coast, and then they would in fact just set off for Britain. So this was, again, a rather full reversal of the Republican position, because now here, Jefferson and Madison found themselves substantially overstating federal power, to some degree even vis-a-vis the states. The embargo failed. They let that statute drop. Madison became president, and ultimately he actually had to threaten force against Britain to gain the trade sanctions that were sought, and that's what ultimately led to the War of 1812, although I'm happy to talk more about that in the Q&A. So in conclusion, Madison's legacy as a wartime president was actually pretty interesting on the states' rights side. And there's a particular episode that demonstrates this, and that is called the Hartford Convention. I don't know why I didn't mean to come and name obscure conventions for you, but these actually all matter. So I mentioned the Annapolis Convention. Who's heard of the Hartford Convention? Non-specialists. All right, that gets a few voices. That's good. So the Hartford Convention was an attempt by the New England states in the middle of the War of 1812, which was going super badly, to convene a convention to talk and hint darkly that they might be interested in seceding from the Union and creating a separate peace with Britain. They didn't want to go so far as to say this, but everyone knew that was what was in play, and Madison, of all people, knew that when you held a convention, it could get a little out of hand, because that's what had happened in the Constitutional Convention, which had originally been called to revise the Articles of Confederation and had suggested trashing them altogether. Now, every other wartime president, I believe, would have shut down the Hartford Convention before it could have happened. And indeed, we have no example of a wartime president in US history who refrained from suppressing civil liberties, with the exception of Madison. Adams had just done it during the quasi-war with France, passing the Sedition Act. And I won't go through all the examples, but you can run through them in your mind. I think no exceptions right up to the present. Party has nothing to do with it. You're president, you're at war. It really doesn't feel good to have people criticizing you. Here was a genuine threat, potentially even an existential threat. Madison let it happen. Why? I think he let it happen because ultimately he believed that if those states were so dissatisfied with the Union as to want to talk this way and engage in this kind of possibility, he had to let it go. They were states. They had the right to talk in this way. Whether he would have accepted an actual attempt on their part to secede is more complicated, but realistically, there would have been relatively little he could have done with it. He had no army that he could have used to try to force the New England states to stay put. In fact, the reason the War of 1812 went so badly is we didn't have much of a standing army, and it turns out militia are bad at invading Canada. Because that was the whole war. I mean, the whole point of the war was just to invade Canada, and that didn't go so well. So again, happy to talk more about that in the Q&A. So ultimately, Madison's legacy, and this is, I think, very important, Madison left office with the deep respect not only of those who had supported the War of 1812, but of the northern states that hated the War of 1812 so much that they were talking about secession. And this is often treated as a puzzle by historians. The war went really badly. We didn't win. We barely survived. Why was Madison, by far, on leaving office, the most popular president in U.S. history? It inaugurated what was called the era of good feelings, and there's a wonderful letter from Adams to Jefferson, Washington was dead, saying, after Madison's presidency, Madison made a lot of mistakes, but he has accrued more glory than the rest of us, the three of us, put together. So that's Adams talking to Jefferson about himself and Washington and saying Madison had more glory. That was the judgment of the age. Everyone thought this. And by the way, Adams was the Federalist, whom Madison never much cared for. He never much cared for Madison. I think a big part of the reason was the respect for civil liberties and states' rights that Madison actually manifested during the War of 1812, such that when they managed not to lose the war, the fact that he had not cracked down on various very threatening forms of dissent turned out to be a big boon. So in conclusion, you can see Madison was in a range of different places with respect to states' rights and with respect to national power. He moved back and forth. He was influenced by political situations and circumstances. And that is okay. That is okay. Because our Constitution has at least two really important dimensions. One is the formal dimension, the written rules of the Constitution that generate official discourse, judicial opinions, legal treatises, attempts to shape our Constitution as law. That's essential to written constitutionalism, and without it, you wouldn't have written constitutionalism. But we also have another aspect, which is the aspect that's studied not so much by constitutional lawyers most of the time as by political scientists and sociologists and historians and people interested in economics. This is the cut and thrust, the struggle of class and caste, the struggle of political power, the struggle of money, the struggles of geography. And those two are a central part of our constitutional legacy, and they are always at work at the same time as our high-flown constitutional ideals are. That is a puzzle, how those two things can work simultaneously, but it is a paradox that has stood us in good stead. And it turns out that the productive tension between these two sides of constitutionalism is the secret of a vital constitutional system that has managed to survive for 229 years, if you count from ratification, and which I believe will survive the next 3 at least. Although I'm open to discussion and debate on that topic. Thank you all very much, and I'm looking forward to your questions. And on behalf of the organizers, may I ask you to please go to the microphones so that the posterity that is recording our conversation can hear your wonderful questions. Yes, sir. Please head to the microphone if you don't mind.
This may be a little bit much, but I wonder if you could speak to Madison's attitude toward freedom of the press, and in particular how it might relate to the events of, say, the last 4 decades in this country.
Yeah, sure. I don't know if I can hit every event in the last 4 decades, but so Madison didn't pay so much attention to the freedom of the press component of the First Amendment when he was writing the First Amendment. I left out a fact that I think probably most of you know, that Madison actually drafted the Bill of Rights, drawing upon, for the most part, rights that had been proposed by various states. Madison, by the way, was against the Bill of Rights before he was for it. He believed there was no need for a Bill of Rights, and during the ratification process, he was desperate that the lack of a Bill of Rights would be used as an excuse not to ratify the Constitution at all. But when he ran for Congress, his constituents demanded from him a promise to get a Bill of Rights passed. So once he was in Congress, he wanted to satisfy that guarantee and also head off any subsequent convention. And so he ended up drafting the Bill of Rights. He didn't pay a great deal of attention to the freedom of the press the first time through. When it started to matter to him was when the Sedition Act was passed. And at that point, Madison said, what is this? This is not freedom of the press. This is a law that criminalizes things being published. And it was used. Dozens of editors were imprisoned and assigned very large fines, fines of hundreds and sometimes thousands of dollars, and imprisoned for multiple years, at a time when the federal government barely imprisoned anyone. Now, I mentioned earlier that the Federalists had a theory of this, and here, sir, by talking about this, I'll be able to get to the contemporary situation. And their debate amounted to the first debate about the meaning of the First Amendment, which we've had a lot more of in recent years. The Federalists said, freedom of the press here doesn't mean anything more than it meant in Britain. That is, freedom from what were then called, and we sometimes still call in First Amendment law, prior restraints, which in ordinary English is censorship. No advanced censorship. The government can't have a censorship office that says you can't print anything unless you come to this office and get a stamp that the censor has approved you. And that's all it meant, according to the Federalists. If you spoke in some way that gave offense to the government, for example, through the crime of seditious libel, which existed at common law, you could be punished, because that wasn't censorship, because censorship was limited to what came in advance. Madison took the opportunity to articulate the very first aggressive defense of the freedom of speech, where he said, first of all, that the freedom of speech did not simply mean that you could only be punished that you could be punished after the fact. Second of all, he said that freedom of speech was necessary to run a democracy. So he articulated the political justification for the freedom of speech. When you're having an election coming, which the election of 1800 was coming, the suppression of the opposition press was going to effectively destroy democracy. That has great relevance to our contemporary moment as well. This fight was never exactly resolved because the courts never fully resolved it. And in fact, the most influential opinions that the courts did come up with took the Federalist side because they were written by Federalist judges. But of course, the Republicans won and then didn't use the Sedition Act subsequently. And I think it was actually eventually, I actually don't remember if they repealed it. Someone will remember if it was actually repealed. It was 5 years sunsetted. There you go. So it's sunsetted without being renewed. Thank you. So an incompletely resolved debate, but the first major First Amendment debate we've ever had. Now, fast forwarding to the last 40 years, I mean, I teach First Amendment, and it takes a while to do the last 40 years, so I'm just going to give you the 30-second version. The big picture of the First Amendment in the last 40 years is a picture of gradual expansion of the freedom of speech from a rationale that was pretty close to Madison's, namely a rationale grounded in politics. The purpose of the First Amendment is ultimately to facilitate life in a democracy by allowing multiple voices in political speech to be expressed. To a view where we are today, where the First Amendment protects a much broader conception of autonomy-driven freedom of expression. To put it crudely, I gotta be me. Part of I gotta be me is I gotta speak. And by speaking, I express my inner self. And so essentially, any form of speech is First Amendment protected. And the government, according to the Supreme Court's latest pronouncements, must be subject to the strictest of scrutiny for any law that in any way impinges on content. So the most recent case where the Supreme Court said this, in an opinion written by Justice Thomas, involved street signs, temporary signs for several different categories. And a locality had regulated different ones differently. So if you had a garage sale, that gave you you had to have a certain kind of sign and for a certain amount of time. If you was a recurring weekly event like church services, a different form of sign. And the Supreme Court said, this needs to be scrutinized strictly, which means and nothing survives strict scrutiny, or very little survives strict scrutiny unless there's terrorism involved. And so, therefore, this was unconstitutional. So that's the shift of the last 40 years, and it's really fascinating because it's happened with the vast majority of the justices on board and all of the conservatives. Of those people, the only one who's really consistent on this, in my view, is Justice Kennedy, because he's a libertarian across the board with respect to expression. So he thinks I gotta be me, therefore I can marry whoever I want and have sex with whoever I want. May not say so in the Constitution, but it's an I gotta be me theory. And he thinks the same thing about free speech. The conservatives reject, for the most part, the view that autonomy is the ultimate value in the Constitution. And yet, when it comes to free speech, they are absolutists. Now, that view can be defended on the grounds that the Constitution mentions the freedom of speech and doesn't mention anything about the other forms of autonomy. So you could try to make a kind of textual response to that. But the problem is that no court has ever interpreted the literal meaning of freedom of speech as really going all the way. Only Justice Black, who was the inventor, really, of textual originalism, before Justice Scalia got to it, ever flirted with the idea that freedom of speech means absolute freedom of speech. So, there's some complexity around that process. Madison wouldn't recognize the First Amendment we have today because it's gone beyond the political justification, and it's adopted a much broader justification. And in my view, an originalist account of freedom of speech would not go anywhere near as far as the Supreme Court's current version does. And it's a fascinating thing that Justice Thomas, who's, in my opinion, the most principled of the originalists on the court, the one who goes for the originalist solution even where it would blow up all existing law, which is a sign of consistency. It may or may not be a sign of wisdom, but it's a sign of consistency, is all the way down on the freedom of speech, and he's very far from originalism on that particular point. So that's, so that's something people will have to figure out in the next generation. Please.
You mentioned the popularity of Madison when he left office. It seems as if Jefferson kind of looms large in the American psyche, and I'm wondering if you can speak to, maybe it's beyond the scope of your book, but speak to Madison's popularity in American history. There's a lot of attention to him now, but why are there Jefferson-Jackson dinners and not Madison-Jackson dinners? Is it just an alliteration thing? Or?
No, it's not the alliteration. So I mean, there are a couple of. It's a great question, and there are a couple of elements. One is that, Jefferson was he was a genius of self-expression. He was a philosophe, if not a philosopher, and he had an incredible ear for phrases that would stick. He liked the most extreme formulation possible. And in that sense, he was remarkable because he had written the Declaration, right, mostly, and that got him tremendous fame and popularity when he was an extremely young man. And he's extremely quotable. What's more, the extremity of his states' rights position was much greater than Madison's. And when Jackson, who when running for office presented himself as a Madisonian, pushed for his more radical small d democratic initiatives, he invoked Jefferson for those accurately, much more than he could have invoked Madison, because Madison was deeply moderate in the end. Furthermore, Madison's legacy was the Constitution. And the Constitution, in his view, was a system of laws that would be greater than any one person. So he loved the Constitution, he felt attached to it, but that was his monument. And the Constitution has always gotten a lot of talk in our country. And Madison didn't really care to or want to be directly associated with it. He wasn't as snappy a writer. And ultimately, he did not have much of an ego. He is one of the most egoless people ever to serve as President of the United States. That may be not saying much. But he himself was really not dominated by ego desire. And he had no need for any legacy other than the Constitution itself. So I think that's a big part of the reason. I think one reason we hear more about Madison today is we're in a moment, and we have been for the last, say, 15 or 20 years, where the Constitution is more important to us than it has been in the past. And there are a lot of complex reasons for that. One is our failed attempts to spread our constitutionalism abroad. I was involved in those, so when I call them failed, I'm just trying to be objective. I believe they were well-intentioned. A lot of people don't. That might be one reason. Another, I think, is our sinking worry that maybe our Constitution isn't going to live forever. And Madison knew that was a constant risk. He saw keeping the Constitution alive as a permanent job. And to me, that's one of the things that I've taken most from him. Our Constitution is not guaranteed to continue to exist. It requires constant work and effort. And that's one of the things, to me, that's most important about his legacy. But again, it's not personal to Madison. Please.
Min Lee, I'm a lecturer at Stanford. I was just wondering if you could say more about Madison's views of immigration and the treatment of non-citizens, because I remember you mentioned the Alien Sedition Act, and you focused on the Sedition Act, which provided for government censorship of critics of the government.
Yep.
But then the Alien Acts, including the Alien Friends Act, the Alien Enemies Act, and the Naturalization Act, made it much harder to become, under President Adams, a citizen, and it also allowed the president to throw out of the country any non-citizen that he wanted.
Yeah, Madison was actually, I like any time I can say that Madison was good on something that I like. Everyone does that. I can't say that about slavery. You know, Madison did not believe African Americans were inferior the way Jefferson did, but he had slaves his entire life. And even though he supported repatriation of slaves to Africa, not too many African Americans actually wanted to go. So that wasn't much of a solution. So there's something where I can't be that proud of Madison's legacy. But on immigration, I actually can be. Because Madison was much more than Jefferson or anybody else openly and very strongly against the Alien Acts, very strongly against them. And his close ally, Albert Gallatin, who was Secretary of the Treasury and the single person that Madison trusted most in the government. And I include Jefferson in that because he thought Jefferson had to be managed, but he almost always deferred to what Gallatin's judgments were, was a target of the Alien Acts because Gallatin was himself an immigrant as an adult. Lin-Manuel Miranda, in his wonderful musical, makes a lot of Hamilton as an immigrant, but Hamilton wasn't actually thought of as an immigrant because he came from an English-speaking country or origin, and he had come when he was a teenager. And that was not a contemporaneous perception. This was a world where a lot of people had been born abroad. Gallatin, though, was Swiss, had come as an adult, had an accent, was clearly identifiable as an immigrant, and was attacked as such repeatedly. The Federalists tried to keep him out of the Senate. They succeeded in keeping him out of the House. They challenged his credentials by saying he hadn't been a resident long enough. He had been a resident for long enough, but that didn't stop them. They repeatedly blocked him from confirmation for various other posts, which is one reason he had to stay as Secretary of State for so long, because he'd already been Secretary of Treasury for so long, because he'd already been confirmed into that role. And Madison stood by him pretty strongly. So I think, in contrast, just to show you how tempting it was to do otherwise, Jefferson was not so great on this. I mean, Jefferson wrote a private letter around that time to Madison saying that in Virginia, there should be a law passed that foreigners should be barred from, immigrants should be barred, he called them foreigners, should be barred from juries because they were too susceptible to being corrupted. And Madison wrote back to him like, no, don't say this. This is bad. Don't go. I mean, he did it very subtly, but he sort of said, don't address this issue. And luckily, Jefferson didn't take that concern public. So Madison has actually a pretty good record on that.
Hi, I'm Zach Stone. I'm a graduate student at Cal Berkeley. So every few years now, it seems like we have these sort of movements for secession. Previous administration, we had them in Texas. Now we have them in California. Mm-hmm. To me, at least, these seem frivolous, but I wonder, these people seem to have these genuinely held convictions, at least as much as the attendees at Hartford. If Madison were alive today, how do you think he would feel? Would this be a case where he really would have a change of heart?
Well, we do know a little bit about that because Madison lived a very long life. And he had another 25 years of life after leaving the presidency. And that meant that in the 1820s and 30s, when Southern secessionist sentiment was just beginning to bubble up, he was frequently dragged into public debates. He really tried to avoid that, but he was dragged into public debates. And the one thing that really got him going was the Southern argument, states' rights argument, that the states actually had the capacity to utterly refuse federal governmental federal laws. And that had put him in a very awkward position because he had written these Virginia resolves, which almost said that, and because Jefferson had written the Kentucky resolves, which really did say that. But Madison was pulled out of retirement to try to defend himself and Jefferson, which he did, a teeny bit disingenuously in the case of Jefferson. He basically denied, in an article in North American Review, which was the most widely read publication in the United States by educated people in the United States at the time, denied that Jefferson had actually called for state to interpose themselves. And then later, like a year later, he wrote an erratum. Yeah, I guess he kind of did. But so, and Madison's, he knew or should have known that he was going too far, but as he said, Jefferson was a genius, and geniuses tend to overstate themselves. So we know that Madison was actually concerned about that, and in the secession debate that he was dealing with, he was strongly opposed to the rumblings of secession. As for the contemporary situation, I think it depends whether you think that these contemporary secessionist talk movements are, no one thinks they're actually going to secede. I get that part. The question is, do you think that that's an effective way to draw public attention? I think he would not like anything that genuinely endangered the Republic, but I do think that Madison was open to rigorous statements of resistance to the national government, and that's what's going on. I mean, when Texas doesn't like what President Obama was doing or California doesn't like what President Trump is doing, it's an expression of a state-based sentiment that the country is going in a way that we don't like. Last point, this is sort of interesting. Not a coincidence that these are both huge states. You know, it's huge in geography, huge in population. Madison did not want the Senate to have 2 representatives for every state of every size. He went into the Philadelphia Convention expecting proportional representation in the Senate. And his view was that the small states would be forced to accept it. He was from Virginia, which was a large state, but it also went to his overall structural picture of what the new Constitution was going to do. If the national government was going to rule the states, it only made sense for the national government to be democratically representative of everybody. Well, everybody, and in his case, he would have been happy to maximize the representation of African Americans because there were lots of enslaved African Americans. He would have liked to maximize their numbers at that stage. So, and he was enraged by the Great Compromise that gave the small states this power. So he would have some twinge of sympathy for large states, feeling that the small states are somehow, standing in the way of those states exercising the influence that they believe they rightly ought to on the basis of their population. Sorry, should I go this way? I'm just alternating sides.
Thank you, Professor. I actually have 2 very brief questions. The first one is, Madison presidents coincide with the revolutions in South America and the initial part of the collapse of the Spanish empowerment in the region. I was wondering if, during your research, you find something like the thoughts of Madison regarding that revolution and how the United States can influence or not the constitutional discourse in those revolutions.
Yeah.
And my second question is, right now the selection of judges for the Supreme Court is highly partisan and political. I would like to know if Madison have any thoughts regarding what would be the ideal form of selecting judges in the Supreme Court.
Well, the latter one is easy. It didn't really dawn on them that there would be this depth of partisanship. I mean, there's a great line when Jefferson, who was a cousin of John Marshall, became the Chief Justice of the United States, and Marshall was that rarest of things, a Virginia Federalist. And in this letter, Jefferson to Madison, Jefferson is complaining about his cousin, and he says, Marshall is driving me crazy, and then he says, this is wonderful, the best thing that could be done with him would be to make him a judge. I love that line. It was still many years before Adams made him a judge. But they just didn't have that conception. However, once Marshall was Chief Justice, they did see partisanship. I mean, Marbury against Madison, one of the most famous cases in the U.S. Supreme Court history, is a deeply partisan performance in many ways. With respect to your first one, yes, but it's a little embarrassing. Madison's first reaction was opportunistic. So he was very interested in the United States taking title to the 2 Floridas, East and West Florida, and the opportunity to do so came when Spanish imperial rule collapsed there. And so Madison sent money and representatives and some arms with the goal of getting people in each of these Floridas to declare themselves as little republics and then pass little constitutions and then magically vote to join the United States. It worked in one case, it failed in the other case, but Madison was very interested in territorial expansion. And he saw this as an opportunity to do so. The inspiring rhetoric of revolutionary constitutionalism that actually appealed to him was in France in the early years of the revolution there. Jefferson was living in France and was writing to him and kept on telling him, because as you know, Jefferson was very attracted to the French Revolution in its early incarnation, saying, they're doing exactly what we were doing. They're copying you. It's all about you. And that made Madison feel very happy. And he and Jefferson were extremely pro-French, and they were very slow to realize that the French Revolution had gone terribly, disastrously awry. Indeed, after the execution of King Louis Capet, as he was called when they were executing him, almost silence from Madison and Jefferson, including notes, thinking that, well, if he deserved it, I think Madison says, the local opinion here is that if he was executed, he probably deserved it. So, they were pretty deep. They were pretty deep in there. Not great judgment. They realized they were wrong later, but it just took them longer to realize that than it should have done.
You mentioned that Gordon Wood argues for the consistency of Madison over his political career. Could you explain what that argument would be by Wood or anyone else?
Yeah, and he actually expressed this in a very concise article published many years ago now, probably almost 20 years ago in the New Republic, called something like, "Is there a James Madison problem?" I think that's what it's called. And I bet anything you can find it by just typing that in online. So that's just as a preface in case I don't do it justice, which I probably won't. I mean, essentially Wood's view is that Madison was a centrist all along, and the rest of the world was moving around him. That he wanted a kind of centrist view of a balance between the national government, what came to be called the federal government, and the states, that he wanted a balance in Philadelphia. But at the time, everyone else was focused on, everyone else was trying to pull the states further apart, so Madison was in the middle trying to hold them together. Then came the Federalists, and they wanted to exaggerate federal power, and so Madison remained in the center, but now the natural emphasis was more on the states. So that's essentially his view, that Madison was a centrist and everybody else was moving. There's something to it, but I think it understates the depth of Madison's actual development and shifts. Gesundheit.
So I had a question about Madison and Jefferson. In your research, did you find anything about any collaborations or how much Madison was influenced in drafting the Bill of Rights by Jefferson? And the reason I'm asking is, Reynolds v. U.S., which for some reason I keep reading a lot.
It's a good case. I just taught that 2 days ago.
The Supreme Court put a lot of weight on what Jefferson had written to the Baptist and what he had said in other spots. And at one point, I think the phrase they used was that his words were authoritative in both scope and effect of the First Amendment. So I'm really curious as to how much input Jefferson really had on the First Amendment.
Yeah, zilch. And that's Chief Justice Waite doing a kind of proto-originalist thing. He got those materials, as you probably know, from a neighbor who was and friend who was a historian. Jefferson was, as they say, in France. They say that in the musical. And he had really nothing to do with drafting the First Amendment, except insofar as he did write a letter to Madison criticizing the Constitution for the absence of a Bill of Rights. And he gave a list of rights that he thought should be in there, and freedom of religion was certainly one of them. That said, when it came to the freedom of religion, and this is maybe a nice place to go, I guess we have room for maybe time for one or two more questions, but just as we sort of head towards the end of this, because of Michael's interest and my interest in free exercise of religion, Madison really is an absolutely central figure with respect to free exercise, and it's also the issue that brought him into public life. Nothing really, when Madison was just out of Princeton, living at home in Virginia, living back at home as a post-college person, I can't imagine that any of you could imagine such a thing, not able to regularly figure out what to do with himself. The only thing that really motivated him and got him excited in his letters was religious liberty. He was very angry about the oppression of local dissenters, including Baptists. And he then went to the Virginia State Constitutional Convention and made his reputation in the state by introducing language that introduced full and equal right to freedom of conscience, which is a big improvement over the toleration guarantee that the original text had provided for. So Madison cared a lot about that issue. And notably, and this is significant for the Waite opinion, Madison really was of the school that thought religion should be protected because of its unique status. The goal was not to protect the state from religion. The goal was to protect religion from the state. Jefferson was, especially after his time in France, deeply anti-clerical and deeply skeptical of religious influence on the state. He was also affected by the way that New England Congregationalist ministers preached against him in 1796 and in 1800. So there was also a partisan component. And his letter to the Danbury Baptists, quoted in that opinion, is, to come back to a theme from earlier, also a political performance. His insistence on a wall of separation, a metaphor that he took from Roger Williams and changed the meaning of, is meant, yes, he's speaking to Baptists who believe themselves in protecting religion from the state, but he's thrusting at the Baptist opponents, namely New England Congregationalists. Remember, those Baptists were in Danbury, Connecticut. So he's sticking it to his enemies, who were the Congregationalists, who did believe that religion should influence the state. Right? Congregationalist ministers gave one of the great genres of Congregationalist literature is the election day sermon. Right? It goes all the way back in New England to long before the United States. And so Jefferson's hitting at them. So that sort of tendency, the treat the separation of state as in part a protection of the state from religion is very Jeffersonian. So you can see why it's used in that Reynolds opinion, which, sorry for the inside baseball, but that's the opinion where the Supreme Court held that the LDS Church did not enjoy a free exercise right to exemption from anti-bigamy laws. So it's being used there because that's an opinion where the court is essentially saying no to religion because the state has an independent interest in enforcing behavioral laws. Anyway, we should let the other people ask their questions, and we can talk about it offline afterwards. Is that okay? Okay, last questions.
Hi, Melissa, graduate student. What about the concept that the Constitution holds back America? So, for example, a modern practicing Jew who I've met will eat shrimp because at the time that the no seafood rule was put through, there weren't any fridges, but now there are fridges. So people aren't dying of food poisoning, as what sort of led to that guideline. So by the same logic, if I have the right to bear arms, then I can ride a horse on the freeway.
Sorry, what did the horse have to do with the freeway?
Well, because at the time that we had the right to bear arms, we rode horses. And I will specify, I am actually the French Huguenot who founded Florida. So I was here before the Mayflower, as in my family. I'm the eldest of that line.
I figured you meant your family. Yeah.
So when I became a US citizen, they accepted my sovereignty, but I said I'm not going to do a coup d'etat, so I'm sorry to disappoint some.
So, you raise a very interesting topic, which is the analogy between religious law and its evolution or non-evolution, and constitutional law and its evolution or non-evolution. So in some sense, this is the deepest question in constitutional law, and it's one of the deepest questions in religious law as well. In the context of but I think there is maybe one possible difference between the two situations. If you follow religious law because you believe it to be a divine decree, you might believe, you don't necessarily have to believe this, but you might believe that the original rationale for the law might not be a reason, the moving away of that original rationale might not be a reason for you as a human being to flout the law. You might think otherwise, right? Reform Judaism does think otherwise. Orthodox Judaism thinks that just because that's the reason for the law doesn't mean you get to break the rules, right? I mean, that is in fact the central dividing line between Reform and Orthodox Judaism. In constitutional law, this is roughly speaking the debate between originalism and living constitutionalism. It's not the only issue, but it's an issue. And there the question is there something like a divine author in the room? Sometimes, Madison wanted us to venerate the Constitution, his word. And venerate is a religious word. And one of the effects of that veneration is for us sometimes to think of the Constitution in quasi-religious terms. Sandy Levinson, a professor at the University of Texas, wrote a book, a wonderful book, now probably 25 years ago almost, called Constitutional Faith, where he plays out these analogies. From the standpoint of the living constitutionalists, the view is something like, this wasn't written by God. I love James Madison, but not God. He was not God. And so, therefore, there's an argument for a greater degree of flexibility in interpretation. Originalists, though, are interested in an authorizing aspect of the public meaning of the document as ratified. And in that moment, in some way, the voice of the people is the voice of God for purposes of validation. So, I think there's room for all different configurations of views about the relationship between constitutionalism and religion, but there are certainly some interesting analogies.
Thank you.
Last question.
The Constitution is 229 years old. You said you hope it lasts another 3 years?
I mean, I hope it lasts longer than that, but I just thought that was a catchy number.
At least. And I'm just wondering if there's any indicators that we should watch for. And I guess what I'm thinking of, it makes me think of like the nuclear clock, we're 2 minutes from nuclear war. Are we 5 minutes from shutting down the Constitution?
Yeah. I mean, this is a rich and fascinating topic. We could spend all night on it. I just want to say, and I don't think you want that, but I will just say very briefly that when it comes to the formal aspect of the Constitution, written doctrines, judicial decisions, the ecosystem of legal organizations and courts and lawyers has, I think, done on the whole, not perfectly, but on the whole over the last year, a reasonably good job of distinguishing between presidential action that violates constitutional doctrine as written and therefore needs to be reversed, and presidential action that may break the unwritten norms but isn't flatly unconstitutional and is therefore a matter for the political branches to address. Right? You could distinguish, I don't know, the travel ban in its iterations 1 and 2, which various courts blocked, from the question of the firing of Jim Comey, which is a matter for politics and is being dealt with in the space of politics at the moment. So, you could point out many concrete examples where it doesn't quite work out that way, for sure. I mean, I thought, for example, that when a federal district court in California a couple of weeks ago blocked President Trump from repealing DACA, it went much too far and brought in disrepute some of the judgments that I think are correct, striking down some of the president's actions. So it's possible for it to go too far. And I have friends to my left who think that that decision was correct, which I find astonishing, but they're very great, professors of administrative law, among other things. I think they're really missing the forest for the trees, but they have this view, and who think, broadly speaking, that the courts haven't done enough. So, I mean, this is just my own view. So where I stand now is I'm pretty happy with how civil society has done, and I'm pretty happy with how the judiciary has done. But when it comes to challenging the unwritten norms of how our government works, we need our political system to do that. The judiciary isn't built for that, shouldn't be built for that. And so the question is, how will the political system do? And that, I have to say, still remains to be seen. We have a president who got elected by breaking the unwritten norms of running for office. I'm just talking about, how he ran. I'm not talking now about, what might or might not have happened behind closed doors. And who believes in governing in a way that he breaks what is lawful for him to break, namely the unwritten norms. So I am a believer that those unwritten norms play a big role in our constitutional democracy. I don't think, to go back to the question of the shrimp, I don't think you can get 229 years out of a document unless you are pretty flexible in your interpretation of it. Right? I mean, I know this is a Federalist Society event, so I apologize for saying this. But the Federalist Society is open-minded and believes in freedom of speech and freedom of expression, so it's okay for me to not be purely along the party line. I tend to think that we need those norms to work. I don't think it's the job of the courts, so here I'm on with the Federalist Society. I don't think it's the job of the courts to make those unwritten norms work. I think that's the job of the political branches. So that's the thing to watch. Watch this space. Thank you all very much.